far. So as you all know, we've got Paul Gaines here, but Paul is an associate with the firm of Roberts, Markell, Weinberg, Butler, Haley. Paul practices in the exclusively corporate representation of property owners association and in the firm's property owners association team. Mr. Gaines graduated from the University of North Texas with a major in philosophy and minor in political science. And then after graduation, Mr. Gaines attended St. Mary's University School of Law in San Antonio. During law school, he worked for an energy law firm concentrating on title examination for clients in Texas and other mineral-rich states. He also served as the president of the Oil, Gas, and Energy Resources Law Society, as well as treasurer of the Federal Bar Association. Mr. Gaines, Paul, as we know him, who is a good friend and colleague, has advocated tirelessly on behalf of associations, community associations. During this most recent legislative session, he advocated tirelessly in favor of and against bills that affect property owners association, and we welcome him today to discuss the outcome of that session with us. We also have Sandy Denton. Sandy, I could bring up your bio. Sorry, Sandy. Sandy is currently the general manager for the Sienna Plantation Associations in Missouri City, Texas. Sienna is a large master plan community encompassing over 10,000 acres and currently has approximately 9,000 homes, with another 5,000 planned. Prior to joining Sienna in January of 2005, Sandy was the executive director for First Colony Community Association in Sugar Land, Texas, a very large master plan community consisting of over 10,000 acres and approximately 12,500 units. Sandy was with FCCA for over 15 years. Sandy is a professional certified association manager, PCAM, and a large-scale manager and a certified manager of community associations. She is a vice chair of the Board of Commissioners for Community Association Managers International Certification Board. In 2005, she was president for Community Associations Institute, and in 2013, president for the Foundation for Community Association Research. Currently, Sandy serves as chair of the Large Scale Committee for CAI, faculty for CAI, and is a member of the Government and Public Affairs Committee. She has been actively involved with TCAA, the legislative voice for community association in Texas, including past chair. Sandy also provides consulting services to associations and managers in governance, long-term and short-term planning, team building, partnering, and other distinctive solutions for their organizations. And with that, I will welcome Paul and Sandy, and please talk to us about this legislative session and all of its ramifications.
Great. Thanks, Leah. I'm going to take the first section, and then Paul's going to provide you with more details on the bills, and then I will wrap it up for you. So it was quite an adventure. The last several months is probably the best way to explain what we've experienced. So what I want to do is kind of give you some framework for TCAA and kind of how the process works. So TCAA, Texas Community Association Advocates, our purpose is to be the legislative voice for associations throughout the state of Texas. We are here to promote legislation to create an environment that supports community association living in a positive and transparent way. We want boards to be well educated. We want members and residents to understand what their association's role is, with a big picture of making sure that our associations are well governed and well managed throughout the state. The other aspect that we always look at when we're looking at the different bills and going through our process is we don't want to increase the financial burden to an association. And then we always want to support things to increase the transparency of associations. TCAA has multiple relationships. So we have relationships with Community Association Institute. We are the representatives of CAI from a legislative perspective in the state of Texas. We also have relationships with the chapters. Certainly in the last year, things have been a little bit different with many of us continuing, or in 20 doing things virtually for the first time and now continuing to do that. We have other relationships throughout the state, including with different business partners and homeowners associations, property owners associations, et cetera. From an advocacy perspective, we again are speaking on behalf of all of the residents living in community associations. Some of the advocacy efforts that we take are, we have a lobby team, and so we engage a lobby team biannually, and we're typically hiring 2 to 3 different lobbyists during session to work on our behalf. And depending on what is happening throughout the year, we may have to bring someone extra on, which is what we had to do this year, once we saw what was happening with the types of bills coming forth. In the interim, so in between when our legislators are in session, depending on the nature of what happened in the last session, what we expect to happen in the next session, and or interim charges that are passed down by the governor or special sessions, will determine whether we need to engage a lobbyist during the interim. At this point, because we know we have a special session, and while the governor gets to define what those topics are, we don't know yet that he won't incorporate some that impact us. And so right now our lobbyists are continuing to work. In the end, throughout the session, and even in advance of the session, our lobby team are actually having constant communications with the different legislative offices. Typically, a legislative office will have someone assigned to certain types of bills. So our lobby team develops those relationships with the staff member involved in that, as well as the chief of staff and certainly the legislator. As the legislators change, so we have elections and more come in, our work increases because we have to continue to educate their staff members and those legislators about community association living. A couple other advocacy efforts that we take. We have the Rally Day, which has historically been in person, except for this last year. And that's a great way for us to reach out and talk to the legislators while they're in Austin about community association living. And then this year you saw a lot of calls for action. And that's when we really need you to reach out to your specific legislator and ask them to take specific action. Periodically, you'll get legislative alerts from us on different things. We're going to go to the next slide, the board of directors. So our board of directors is made up of representatives throughout the state. We try to balance it between Houston, Dallas, Austin, and San Antonio. And then we want to make sure that we have managers, attorneys, business partners, and homeowners on the board of directors. Right now, Paul is the only member on the board who is specifically from San Antonio, but some of our other folks do work around the state also. I am currently an ex officio officer, setting out a session based on what our bylaws require. During session, the board of directors meets weekly, and I'm going to talk to you kind of about what we do with the bills. And then depending on what else is going on in the interim, we may meet monthly or less frequency. Again, kind of depends on what's going on there. So from a legislative process, what happens? So anyone can try to introduce a bill. So constituents will often bring forth concepts of bills and or interest groups. And they have to find a sponsor. So they have to find someone in the House and the Senate who will sponsor their bill for it to actually be able to move forward through the process. Different people might write the bill. The Texas Legislative Council is really the, I guess, the last route that a bill goes through to make sure that it is written in proper format and then can be presented for consideration. We do have a long period for bill filing, but it's defined, and there's thousands of bills that come forth. Every time a bill comes in, we use what we call our bill review team process. So we have folks throughout the state, both a manager and an attorney, typically 2 on each bill review team. And we review any bills that we believe will affect property owners associations, even if they don't say the word property owners association. They may have some other subject. A good one this year was kind of the golf cart bill, which Paul will talk a little bit about, but it didn't necessarily say property owners association. So we do have to be aware of bills that are not specifically calling out a property owners association, which is the terminology the legislator uses for homeowners association, and then they'll use condominiums for the condo. And then the bill review team will go through the process of evaluating the bill, identifying what is the impact, and then making a recommendation to the board of directors in terms of, is this a bill we support? Is this a bill we want to try to amend? Are we going to have to oppose this bill? Are we just going to monitor it to see what happens through the process? Are we going to do nothing about the bill? And this session, we had a variety of all of those. Once a bill is in the House or the Senate, it is then assigned to a certain committee. Most of our bills in the House go to business and industry, and in the Senate, they go to business and commerce. Committee members are assigned at the beginning of session. So again, depending on if someone got reelected or newly elected, affects who might be sitting on the committee. Those appointments are very political in nature. And so in some cases, we'll have the same committee members moving forward from one session to the next. In others, we don't. We typically have some change. The volume of change will determine how much re-education we have to provide. The committees actually set the hearing. So the committees determine if a bill is going to move forward or not. If a committee chooses to do nothing with the bill, it dies in committee. But if the committee holds a hearing, then we are in a position as TCAA to try to figure out, are we going to testify? If so, who are the right people to testify? Depending on the nature of the bill, it may be best that we ask a homeowner volunteer to testify versus an attorney or a manager. So each bill, we have to give consideration to who might testify on our behalf, and then they're provided, whoever's testifying for us are provided talking points so that they understand the messages that we want to send to the legislators on those committees. Once a bill makes it through a House committee, then it has to go to the Senate and vice versa. Throughout the whole process, changes can take place. That is a significant part of what happened with Senate Bill 1588, which is what is our really exciting bill this session that Paul's going to talk about. But there were a lot of changes throughout that. And so what happens is it has to go back and forth between the houses. So each floor takes action on their bill. It goes to the other house. If the House makes changes to their bill, it has to go back to the originating chamber. If the originating chamber concurs with the changes, then it's enrolled and sent to the governor. So it's ready for the governor's action. If the committee doesn't concur, then they call for a conference committee to work out the differences. Again, we had, I don't know, a half a dozen amendments at the last minute on 1588. And so it really made it crazy. In our state, if the governor does not take action by a certain date, the bill automatically becomes law. So he has to very proactively choose to veto a bill. He can sign bills, which he did for us. We're so grateful. So there are deadlines for him in terms of the time frame for when certain actions can take place. So some key dates, next slide. Some key dates, just so you're understanding the whole process that we worked through. November 9th of 2020 was the first day bills could be filed. The legislative session actually started January 12th, but bill filing continued through March 12th. So 60 days after the commencement of the session is when bill filing ends. The regular session ended May 31st, and the governor had until June 20th to veto a bill or sign it. Either if he took no action, again, it became law. So with that, I'm going to turn it over to Paul, who's going to take you through the nuts and bolts of all the good news this session.
Thank you very much, Sandy, and thank you to everyone who's attending this morning. We're going to go ahead and dive right in. We'll discuss first Senate Bill 1588. This is going to be a lot of material today, so we are going to ask that questions be saved for the end. I believe if you do have a question, you can type it over in the chat bar. And then at the end, we'll try to get to as many as we can within the time frame that were allotted for this presentation. After Senate Bill 1588, we will talk about some other new laws that were enacted and that affect POAs in Texas. We'll talk about near misses and TCAA victories. And then lastly, Ms. Denton will discuss the protection of community association living. So Senate Bill 1588, entitled Relating to the Powers and Duties of POAs. This was the biggest bill that we saw affecting POAs this session. And really, this is the main bill that made the 87th legislative session such a wild ride. Today, we will be discussing most of the relevant parts as they pertain to POAs. It's not going to be an exhaustive explanation of the entire bill. The enrolled version did have 27 sections. So this thing is a monster. And today, I'd say most of our presentation will be discussing Senate Bill 1588. June 18th, 2021, the bill was signed by the governor. Certain sections of the bill will become effective September 1st, 2021. This is going to go for most sections, other than the section pertaining to management certificates and then filing with TREC, which is going to become effective December 1st, 2021. So numerous provisions will also apply to single family and condominiums, and we'll discuss which ones apply to condos and single families throughout this presentation. So the first section we'll discuss is swimming pool fences. So this section will add 202.022 to the Texas Property Code. This will prohibit POAs from prohibiting an owner from installing a swimming pool enclosure that conforms to applicable state or local safety requirements. A POA may enforce the appearance of the enclosure, which does include the color, but they cannot prohibit a black swimming pool enclosure that consists of transparent mesh set in metal frames. And we do provide a picture down there that shows exactly what they're trying to get at here, that you cannot prohibit. However, the language of this particular statute, the swimming pool enclosure, arguably, you would be able to put up one of those large enclosures over the entire pool that you see in Florida. And it's very concerning, considering that right now many associations don't permit these. So arguably this statute is really going to shake things up whenever it comes to the pool enclosures. Security measures, another very concerning section of Senate Bill 1588. This will add section 202.023 to the Texas Property Code. It is not going to apply to condominiums. But this bill is going to state that a POA cannot prevent an owner from building or installing security measures. This includes security cameras, motion detectors, and perimeter fencing. However, the language does state, including but not limited to. So the security cameras, motion detectors, perimeter fencing, that's not an exhaustive list in regards to security measures. A POA is not prohibited from banning the installation of a security camera in a place other than an owner's private property, or regulating the type of fencing that an owner may install. The word type is going to be argued over for a long time. What does that include? Does that include the color, the height, wood, metal? Really, that one word, I believe, will be very contested. And right now, if you do have an issue, whenever this does come into effect with a certain fence or perimeter fence or something along those lines, consult with your legal counsel, because a lot of these sections of this bill are going to come on a case-by-case basis, depending on the specific instance or situation that a POA is dealing with. Resale certificates. Senate Bill 1588 will amend section 207.003C of the Texas Property Code. This will cap resale certificate fees at $375 and any updated resale certificate fee at $75. The deadline to deliver a resale certificate after the second request by an owner. So whenever it comes to resale certificates, an owner can request it. The first time, you have 10 business days to deliver that. This is only going to be triggered off the second request by an owner for the resale certificate. It's going to change that deadline from 7 to 5 days. And if you do not provide it after the second request, that's going to trigger these penalties. An owner may seek judgment against a POA for not more than $5,000 for failure to deliver such information. The current amount is $500. So this is 10 times the amount that's currently provided by statute. So a very extreme change in Senate Bill 1588. Online subdivision information. This will amend section 207.006 of the Texas Property Code and will require property owners associations to make current versions of dedicatory instruments available on internet website and available to members. Dedicatory instruments that include articles of incorporation, certificate of formation, bylaws, declarations, amendments, etc. This will apply to property owners associations that are composed of at least 60 lots or a property owners association that is contracted with a management company. So it will be applicable to most associations in Texas. Management certificate filings. This will amend section 209.004 of the Texas Property Code. This will apply only to single family and townhome associations. It requires management certificates to now include declaration amendments, phone number and email address for the managing agent or representative, the website information, and then the amount and description of any fees charged related to the transfer of title. This will also require the management certificate to be filed with the county. Well, we already know that, but the additional requirement of filing with the Texas Real Estate Commission. So not later than the 7th day after the property owner association files a certificate with the county, the association must also electronically file it with TREC, which is again the Texas Real Estate Commission. Now here's the penalty for not filing in accordance with the statute. Owners will not be liable for any attorney's fees incurred by the association related to the collection of assessments or interest that accrues on these fees during the period a certificate is not recorded with the county clerk or electronically filed with TREC. So it's very important once this goes into effect that all management certificates are filed and that they're also electronically recorded with the Texas Real Estate Commission. Next, ACC members and a new hearing requirement before the board for ACCs. This will add section 209.00505 to the Texas Property Code. This will prohibit a person from serving on an ACC if the person is 1, a current board member, 2, a current board member's spouse, or 3, a person residing in a current board member's household. So currently, if you have an ACC member who is any one of these 3 before September 1st, 2021, make sure that these individuals are either off the board or off the ACC. You do not want to conflict with this statute after it becomes effective. The notice of any denial of an ACC application has to be provided to an owner, including any changes needed for the approval. The owner is permitted to appeal a decision by the ACC to the board. If that's the case, the board must hold the hearing within 30 days after the date receives the request. The hearing notice, this will be sent to the owner not later than 10 days before the hearing date, must include the time, place, and date. And then during hearing, the board or a designated representative and an owner are provided an opportunity to discuss, verify facts, resolve the denial by the ACC if possible. And then both the board and owner are permitted to postpone for a period of not more than 10 days, and the audio recording is permitted by either party. So the 209 hearing requirements under Chapter 209 Texas Property Code that apply to hearings before the board, a lot of those are similar to this new requirement under Senate Bill 1588, applicable to the ACC hearings. So board meetings, this will amend section 209.0051 in Texas Property Code. Essentially, this will just change the board meeting notice requirements to 144 hours before the start of the meeting. Currently, it's set at 72 hours, and special board meeting notice at least 72 hours before the start of a meeting. Contract for services. This will amend section 209.0052 of the Texas Property Code. An association must solicit bids or proposals using a bid process established by the Property Owners Association if it chooses to contract for services that will cost more than $50,000. So new rules applicable to the 209 enforcement action notice. This will amend section 209.006A of the Texas Property Code. This applies to the enforcement notice that you send in regards to a deed restriction violation before it is turned over to an attorney. This would require a property owners association to send that 209 violation notice with the opportunity to cure and a right to request a hearing to the owner prior to reporting a delinquency to a credit reporting service. There is also a new change to your typical collection 209 notice. So now, instead of giving the 30 days on your collection 209 notice, Senate Bill 1588 will require that you give the owner 45 days to cure the delinquency before the owner is liable for fees of the collection agent. So whenever this becomes effective, September 1st, 2021, be sure that all of your 209 letters are updated. Scratch the 30 days because now it is 45 days. Credit reporting services. This will prohibit an association or a collection agent from reporting fines, fees, or assessments to a credit reporting service if the charges are disputed. Now, what does disputed mean? That is unclear in this particular statute. Arguably, it would mean it's disputed in writing, just as you would dispute debt under the Fair Debt Collection Practices Act. However, if an owner calls and says, I don't agree with these fees, they are disputed, taking the conservative approach, I would argue that at that time it is disputed. The fees may be reported. Sorry, go back for a second. The fees may be reported only if 1, 30 days prior to reporting, the POA sends notice of all the charges to the owner and the owner has had an offer of a payment plan. These are typical provisions that you see in the 209 collection notice. However, now associations may not charge a fee for reporting a delinquent payment history to a credit reporting service. So before, if there was some kind of credit bureau reporting fee that was being charged to owners, Senate Bill 1588 is going to ban those fees. Now, 209 hearings are also going to change, and not for the better. Section 209.007 of the Texas Property Code is going to be amended. The hearing, not later than 10 days prior to the hearing, the association must now deliver an evidence packet to the owner. This will include the photos, the documents, the communications that the association intends to offer at the new hearing for the 209s. If evidence is not provided, the owner is entitled to a 15-day postponement. And then during the hearing, the board must first present its case, and then the owner is entitled to present his or her case. What this particular statute is doing is changing the friendly 209 hearing into a mini trial by introducing evidence, presenting cases, rebuttals, etc. This is really becoming more of what you see in legal proceedings. So unfortunately, with a lot of these new 209s or 209 hearings after it becomes effective, we're going to be seeing a lot of associations getting counsel involved for these types of hearings because, again, they used to be the friendly, let's meet up, try to resolve this. Now there's all these requirements of evidence, postponements, and then you have to present cases, etc. Lease information. This will amend section 209.016 of the Texas Property Code. An association may request the following information regarding a lease or rental applicant. 1, the contact information. This includes the name, mailing address, phone number, and email address of the tenant for each person who will reside at the property in the subdivision under the lease, commencement date, and also the terms of the lease. And then here's a strange addition that they added to 209. So JP court jurisdiction. This will be added to 209.017 Texas Property Code, only applicable to single family and townhome associations, but it will permit an owner to sue a property owners association for a violation of Chapter 209 in the JP courts. Strange addition, with this 87th legislative session, we've seen a theme. There's been a lot of bills out there regarding suing board members and suing associations in JP courts. At this time, luckily, this is the only one that passed. So that covers most of the relevant sections of Senate Bill 1588, the important ones that are really going to have an impact on property owners associations throughout Texas. But there were a few other bills that were passed that are not favorable to associations here in Texas. A big one being Senate Bill 581, which is relating to the regulation by a POA of certain religious displays. This one takes effect immediately. So if you have a religious display policy, it's going to need to be amended because a lot of the language that's under the current statute has changed pursuant to Senate Bill 581. This will amend section 202.018 of the Texas Property Code. It states that a property owners association may not prohibit owners from displaying on the owner's or resident's property or dwelling one or more religious items. So currently the statute states you cannot have these items beyond the entry of the property. Now it's expanded it to the entire property. So arguably people can put a plethora of religious items in their front yard pursuant to this statute. Property owners association may prohibit a religious display that, one, threatens the public safety, violates a law other than the law prohibiting the display of religious speech, is offensive, is installed on property owned by the POA or in common with other members, or violates any applicable building line, right-of-way, setback, or easement. Senate Bill 30 we'll discuss quickly. This is relating to the removal of certain discriminatory restrictions and provisions from certain real property records. This will permit an owner to request the removal of a discriminatory provision in a conveyance instrument by completing and filing with the district court clerk a motion verified by affidavit that contains the info provided in the suggested form under this particular bill. You look at the language, a conveyance instrument. This really wasn't intended to apply to, say, declarations or other dedicatory instruments. Arguably, you can say that there are conveyance provisions in a declaration. However, the intent of this particular provision seems to be more applicable to deeds and other instruments of conveyance. House Bill 1659, relating to the amendment of a residential subdivision's declaration to affect certain types of property located in the subdivision. So amend section 209.0041 of the Texas Property Code. This is the particular provision that addresses the 67% membership vote requirement to amend a declaration. What this particular bill is doing is just stating that that 67% vote would not apply to an amendment that would affect a portion of a subdivision zone for or containing a commercial structure, industrial structure, apartment complex, or a condo. Senate Bill 318, this one essentially mirrors the open records provisions under 209.005 of the Texas Property Code. Now it's going to make most of those provisions applicable to condominiums. So it will make open records procedures applicable to the condominium association, requires condos to make the books and records, which includes financial records, open to and available for examination by unit owners. It will also set forth procedures to request either one, the inspection or the production of certain association records, and requires condominiums to adopt a records production and copying policy and a document retention policy. If you have condominium associations or you are a board member of a condominium association, you do not have these two policies, you need to jump on these quick. Now these are required. So if you don't have them, make sure that you get with your legal counsel to draft these up and get those recorded immediately. So a new law and a TCAA victory. So this is one that was supported by TCAA. This is House Bill 1281 relating to the operation of certain low-powered vehicles. Golf carts are no longer required to have a golf cart license plate in a master plan community. This next one is a near miss and a TCAA victory. Another one of those bills that was suggesting that you could go off and sue an association in JP court. House Bill 2912. This proposed to add section 209.017 of the Texas Property Code and provided that if a board member violated chapter 209 or a governing document while acting in the capacity as a board member, then the owner was permitted to file a petition against the association in the JP court. If an owner prevailed, then judgment may provide that an association remove the offending board member, award damages, or authorize reduction of assessments based on the damages awarded. Another strange concept that they continuously bring up JP court, owners suing in JP court. Well, JP courts don't have the authority to issue injunctions, which typically if you have a board member who's suing an association, they're typically looking for the association to do or not do something. JP courts has a very limited jurisdiction whenever it comes to what it can do. So very strange statute, but luckily it was a miss. It did not pass, and it was a TCAA victory, testifying against this one at the Capitol and finally getting this one defeated. Next, everyone's favorite bill, the chicken bill, which we've seen multiple times. And I personally got the privilege to go to the the Capitol and testify against this one. There was a lot of people in favor of it, but unfortunately, it was a very poorly drafted bill, and luckily, it did not pass. The original bill, before I go into it, actually allowed beehives, which, as you know, if you have a tiny lot, there are many issues with having up to 3 beehives on a small lot, especially with children and animals in a subdivision. But later on, that was removed, and we were left with the bill that would have restricted associations from prohibiting on a residential lot, 1, a cottage food production operation, 2, the growing of fruits and vegetables in the front or the backyard, the raising or keeping of 6 or fewer domestic fowl, so it's a big number, and or the raising or keeping of 6 or fewer rabbits. So luckily, this one did not pass. However, I have a feeling that we will see that the chicken bill arises in the next session because we've seen it many times before. House Bill 1970, this is another near miss in TCAA victory. So if passed, this bill would have required a association to adopt a fine policy. The policy would have required the disclosure of each type of violation for which the board may assess a fine. It's very difficult to do. I mean, can you think of every single violation that could occur under a dedicatory instrument? No, you can't. It's way too broad, and I don't think that particular provision was well thought out. The amount of the fine for each violation, and then provide the information regarding hearings. The bill also would have required the association to file the policy with the county clerk's office. Well, if you have a policy, you have to file with the county clerk. Regardless, provide a copy of the policy to each owner by posting the policy on the association's website, or annually sending a copy of the policy to the members by hand delivery, first class mail, or email. Just another hoop you have to jump through whenever it comes to fine policies by annually sending these copies of these things to the members. Completely unnecessary, in my opinion. House Bill 2447, this is another near miss in TCAA victory. This bill would have permitted owners holding at least 20% of the voting interest to petition an association and require a special meeting to conduct a recall election to recall a board member. Within 90 days of the association receiving the petition, the association would have to hold that recall meeting. And then if a majority of the votes are for the recall of the board member, the member position would become vacant and the board must fill the seat. This one did not pass. A near miss, House Bill 1467, relating to Property Owners Association annual meetings held electronically. This was actually a pretty good bill. This would have permitted an annual meeting to be held via electronic or telephonic means. As we've seen with COVID-19, holding these meetings electronically has become vital for many associations. And, at the end of the day, some associations prefer it over holding the physical meetings. It's actually a little easier to just hold it via Zoom or some other virtual platform. So this would have allowed those virtual meetings if each attendee may hear and be heard by everyone attending, and if the notice sent to members includes the instructions to access any communication method required to attend the meeting remotely. House Bill 1202, another really good bill that did not pass. It's relating to the amendment of a dedicatory instrument to remove a discriminatory provision. We saw a lot of bills this session regarding the removal of discriminatory provisions. It's become quite a theme, and with these provisions that are still out there in these older documents, there needs to be a requirement or some kind of procedure to remove these from the dedicatory instruments. And I think House Bill 1202 really was the one that would have been best for this procedure. This provided a procedure for the governing body of an association to amend a dedicatory instrument to remove a discriminatory provision by a majority vote of the governing body. 1, on its own motion, or 2, on the motion of a member of the association. This also provided procedures for owners within an association to amend the dedicatory instrument to remove a discriminatory provision through a petition process or amendment committee formation process. So really 1202 kind of encompassed all the different scenarios with an association to make sure that each different type of association was addressed, and that really they would have this procedure to remove these discriminatory provisions if they were present in the governing documents. And with that, I'll turn it over to you, Sandy.
Thanks, Paul. Okay, so when we talk about TCAA's role in trying to advocate for community association living, we also need you guys, managers, board members, other folks involved with community association living to do things. The most significant thing that you can do is to be reasonable in your decision making. While we can't make everybody be happy with the decisions that the board or management are making, we can make sure that everything we're doing is reasonable. So you as board members and managers should step back and say, is your enforcement process reasonable? Is your collection process reasonable? Bills get filed because of specific situations that occurred, which is very definitely the result of many of the bills that passed this session, including 1588. So we can't stress enough how important it is for everyone at the table from community associations to be reasonable in your decision making. Educate yourself. So thanks for attending today to understand what's happening in the new laws. Don't intentionally violate the law. Make sure that you are compliant with the law. Make sure you understand best practices. CAI offers a lot of different education, both at the local levels as well as the national levels on different topics. Stay informed, keep abreast of what's going on. Ask yourselves, in everything you do, are you being transparent? Use experts with community association background. So you wouldn't necessarily go to your local State Farm who provides your auto coverage and say, oh, let's cover this condominium, or oh, let's cover this homeowners association, all of their facilities. So you don't want to do that with your other experts. You want to hire experts, your attorneys who are familiar with community association living, your CPAs who are familiar with what needs to happen with community association. So really think about that in all of the decisions that you're making in terms of bringing in folks to help you, and bring in those folks. Don't just assume you can figure it out. The last thing we need is for someone to inadvertently do something that creates a significant issue and we have a new bill. So reach out for support from experts in the industry. And then develop a relationship with your legislator. So this is very much like if someone comes to you and asks you to do something, you might be a little bit more open if you know them or you knew they knew somebody, right? So from a legislative perspective, it's good timing now that the legislature is, well, we're kind of on a break right now, and then they'll go back into session next week. But you really do want to develop a relationship with your legislator during the interim. So when they're back in their local offices, invite them to your annual meetings, send them your newsletter, invite them to board meetings, communicate with them on a regular basis. Maybe you create a little committee within the association that develops government relations, because it's not important just at the local level or the state level, but it's also helpful at the national level when there's national legislation going on. CAI as well as TCAA have databases of people with relationships. So if we need someone who knows Phil Stevenson to reach out to them, that's what we want to do. So we want you to develop your relationship, and then we also want you to let us know about it. Protecting community association living, you can become a TCAA stakeholder. So we have stakeholders who are homeowners, who volunteer leaders, board members, managers, and our stakeholders are here to support the concept of community association living. And we also need funding. And so educating our legislators costs money. That is our lobbyist team. We have an administrative team. And so I'm going to talk a little bit further about funding, but that certainly is one thing you can do as a stakeholder. Support on-site advocacy. So support the concept of advocacy in the state, at the Capitol in Austin when our legislators are there, and build those relationships with your legislators that then transition to when they're in Austin. Do you have key contacts? Do you know folks in the legislative arena? So even if they're staff people working with the legislator specifically, that's a valuable relationship to know. be seen and be heard, come to Rally Day. Get your board members to come, or managers to come, or business partners to come. You know, for some of our business partners, these bills are affecting them. There's one of the languages in 1588, questions whether condominiums can actually collect money if it's not specific in their declaration. So that affects a lot of our business partners' ability to have business. Provide TCAA with feedback. So if you attend Rally Day, we want your feedback. We send out the minutes throughout session and we provide summary reports. Let us know whether that's answering your questions, providing you the information that you need. And finally, another step in protection of community association living is we really need funding, and we do need some volunteer support. So on the TCAA website, there's some information about recommended funding levels. For you as managers and board members, budget for it. Put it in your budget every year. Even if you can't meet the recommended levels that is on the TCAA website, any amount of money helps. And if you do it every year, even though we are not in session every year, and transmit that money to TCAA, that helps TCAA have funds available. So when we get into a legislative session like we did this year, when we needed another lobbyist, we don't have to reach out and ask other people to contribute, which is what happened this session for us to bring in the other lobbyists. So really strongly encourage you to budget for this and make contributions on a regular basis. Depending on the way your articles of incorporation or certificate of formation or wording, you may not be able to per se help fund lobbying efforts, but you can help educate. And that's what we're asking you to do. So with that, I believe we are ready for Q&A. And so I think Leah's going to handle that.
I am, and believe it or not, we only have a couple of questions. The first one is from Terry, who wants to know if the term religious was defined, meaning limited to Jewish, Catholic, or Christian displays, or does this open the door for radical groups or others to claim their group is religious?
So the term religious is not defined. This would not be limited to just Jewish, Catholic, Christian ideals. The key language is related to the sincere religious belief under the particular language. So would it open the door to what you would call a radical group? It depends. It all depends on, again, that sincere religious belief. What does that actually mean? Well, it's subjective, right? I know that there are many what you would call religions out there that are considered religions now, but maybe some people would not think that they were religions. For example, I heard somewhere that, Star Wars Jedi is a religion these days. Would it encompass that? Arguably it would.
Thanks, Paul. Second question, how does an HOA ensure that their management company follows the new requirements that the HOA is ultimately responsible, i.e. 209 notifications, filing of governing documents, etc.?
So now more than ever, associations need to work with their legal counsel to make sure that they got all their ducks in a row. Anytime that we get a collection account or something along those lines, my firm specifically checks the requirements of the 209 letters, make sure that everything's compliant before moving forward. We also do a health check of the association to make sure that everything's filed that needs to be filed. And again, just making sure that the association has everything they need in order to be compliant. So as stated, the management company, the association, and the legal team of the association need to work together to make sure that everything's good moving forward after this becomes effective.
Right. I might add to that is, as board members, make sure that you are being educated. So you're at least aware that these changes are coming forth. So you at least have the base knowledge to be able to say to your management company, what are you doing to make sure that we're compliant with this?
Art would also like to know if TCAA or CAI will be providing any boilerplate examples of some of the newly recommended policies.
TCAA and CAI will not be providing examples of these policies. If an association needs these policies, they should be drafted by an attorney, and the association should reach out to the legal counsel to get these policies drafted.
Got a question from Danae. Does 1588 prohibit prior collection agencies fees that were charged to the owners prior to September 1st?
Prior collection agency fees. I think maybe we're talking about the credit reporting fee. So I don't know if this is going to be retroactive. So is this bill, whenever it becomes effective, is it going to apply retroactively? In that regard, if there are credit bureau fees, I would take the conservative approach and say don't try to collect them after this particular bill becomes effective.
Danae would also like to know if 1588 prohibits management companies from charging for statement of accounts if a resale certificate was not requested.
I didn't see anything regarding statement of accounts or charges for that. I believe that if that is wrapped into a resale certificate fee, then it just cannot be more than that $375. But if there was no resale certificate requested and there is a, say, administrative fee for a statement of accounts, I don't believe there's any language in Senate Bill 1588 that prohibits that charge.
Those are all the questions, guys. Believe it or not. You're getting out early today. Do we have any? Oh, we have one. Oh, here they come. Okay. Does the credit reporting section apply to admin fees?
It does not. It's very clear that it's for a fee for the credit reporting service.
All right. Does 1588 prohibit management companies from charging for an attorney referral fee?
That is not language. It's within Senate Bill 1588. That particular fee is likely going to be controlled by the contract between the association and the management company.
All right. Last call for questions. Take your opportunity while you got them here. All right. I don't see any other questions. So with that, I'm going to thank you guys for coming here today and giving us this update. I know everyone really appreciates it. And I know there are a lot of question marks and a lot of unknowns at this point, how things are going to shake out once these bills become effective on September 1st. So definitely reach out to your legal counsel if you've got questions. And Paul and Sandy, this presentation will be made available on our chapter website, right, Jesus? And we're also recording the session. So if anybody who was not able to make it today, you want to reach out to those people, let them know that there is a recording so they can obtain that information and hear the presentation again if they would like. I've got a thank you from Brady. Thanks, Sandy and Paul, for all your efforts and hard work during the session and in addition to today's presentation. So thank you, everyone. Before last call, while we're all still here together, there's not too many of us. If anyone wants to unmute and ask a quick question, go ahead. Nope. Okay. All right. Well, then thank you, everyone. Thanks again, Sandy, for coming. And thank you, Paul, for all of your work this session. We know how hard you guys really worked for community association. So thank you.